All right. And I'll come back to the relationship between the DPP and the judiciary, yeah. But let me take you forward to your relationship with the DCI. And one of the reasons that perhaps some of the cases have failed is because of the...
Which cases, may I ask?
They have not succeeded. We haven't seen a prosecution that has resulted to a conviction. But I'll give you the example then. You want to know a specific one?
Yes, please.
The DCJ case that collapsed in court. That's a case that failed.
It's not collapsed in court.
It collapsed in court.
No, it didn't.
What happened?
We appealed. It's still in court.
And you went straight to the Judicial Service Commission too?
We did, yeah. We went to the Court of Appeal.
If you're confident of the court, why did you do that?
No, but what is the Judicial Service Commission? It's part of the judiciary.
Yes.
And those were directions that we were given by the High Court. So what we did is we picked the areas that the High Court said should go to the Judicial Service Commission. In our opinion,
yes,
that shouldn't have been the case. But we accepted it.
It's a lose and win whenever you take a case in court.
Well, I mean, and this is one thing Kenyans also need to understand.
Yes.
Prosecution does not necessarily lead to convictions. You can lose on technical grounds. We're all humans on maybe evidence that the judiciary feels, or the judge or the magistrate who is sitting feels has not reached the threshold. Now again, this is very relative because the discretion is on the individual. And we vary as human beings when you look at the law and sometimes when you interpret. But we respect that. We respect the rulings by the judiciary even when we feel aggrieved. But then again, the Constitution and the laws provide that when you are aggrieved, then you can appeal,
yes.
And this is what we've done. So the areas for the DCJ that was clearly spelled out at the High Court, we took that to the Judicial Service Commission, okay. And we even had more in terms of infractions that she was involved in, and we presented that.
Okay.
Yeah.
What Kenyans remember about this case is the fact that they said that the DCI did not properly obtain the evidence that was presented in court.
Those are the areas that we are appealing on. Because
yes.
In our opinion...
it did not matter how you obtained the evidence.
No.
Yes.
It does matter how
yes.
you obtain the evidence,
okay.
that we obtained it rightly.
Okay.
And we have the evidence to show that. The thing is, when they went to the High Court, these were not areas that the judges were supposed to
consider.
Yes, to consider.
Yes.
This was outside the appeal. It was outside. I'm trying to look for the right word. It's escaping, but it was outside.
What you asked
the applications,
yes.
Yeah, not us, but
yes.
The DCJ.
The DCJ, yes.
And it came to a surprise.
Okay.
For us, it was a surprise. It was unusual, but we accepted it, and we said we're going to appeal,
okay.
Because we felt that the judges erred in law.
And you agree with that ruling, but you obviously...
We don't agree with it.
I mean, you accepted it at that time.
No, but what option do we have?
You had to accept it. No, but your manner of accepting it, that is what's questionable.
We didn't accept it.
Yes.
That's why we have appealed.
Yes.
Yeah.
Accepting in that you said, fine, it's okay with what the court has said, but we're going to appeal.
No. We didn't accept.
You didn't accept it?
What we've accepted are the principles laid in law.
Okay.
That when you're aggrieved with a ruling, then you can appeal.
You can appeal.
That's what we've done.
All right.
Yeah.
Why did you sit at that press conference with the DCI? Honestly, why didn't you just use your lawyers to go back to court instead of holding a press conference? Because you have been accused of prosecuting your cases in the media. Why did you have to do that PR exercise?
No, it was not a PR exercise.
But why did you have to do it?
We had to do it to inform the public. And that's part of the Constitution, the right to information, as to why we make certain decisions. And this is why we do what we do.
Okay.
When we give press statements, when we explain to the public what is going on.
Okay, so we'll take that was the explaining part. Good enough. Don't you think, inevitably, now talking about your relationship with the DCI, yes. They are setting you up to fail because they're giving you weak evidence to present?
No, but Mjunga, I've been very strict.
Yeah.
If you look at the number of cases that we've brought, and you understanding the amount of graft in Kenya, and sometimes even the cases that as NTV you have highlighted, I think the number of cases are very few.
Okay.
And this is because we have continuously asked the investigators to go back and do more for us to be able to prosecute.
Indeed, we've seen cases that you have referred back for investigations.
Yes,
That's very true.
That's very true. A lot of them, and even those ones that we give consent, if you follow the chronology of the statement that we give and the dates, you will see that it took time before we arrived to the decision that we arrived at.
All right. The judiciary, the DCI, now the other link that perhaps is weakening your work, the lawyers, have you considered, because I'll give you an example.
Which lawyers?
The lawyers who are involved in these cases, not yours.
Okay.
I'm just looking at the weakest links
Yes.
in your work, the prosecutions of these cases. I'll give you the example of a NHIF case that is yet to begin, and we have 74 witnesses lined up by the prosecution. We have about 30 lawyers. Now, if you look at the act that gives you your mandate to prosecute corruption, it says 2 years. The cases should be concluded, right?
No, not necessarily.
It's not 2 years.
No.
How long? Is it open in the period that you should be prosecuting cases?
It's open. It depends on the judiciary. It depends on when the judgment will be given at the end.
Okay.
The 2 years I think you're alluding to is the suspension of the state officer or the public officer. It should be at least within 2 years.
What is supposed to happen with those 2 years?
Well, they envisage that within those 2 years,
The case shall have been concluded.
yes.
Exactly.
But then this is just to make sure that you don't really overtly penalize an individual, because there is a situation where even after you finish within a year, then you don't return the individual back to office.
Okay.
But then it is simple. If it's after 2 years, then the administrative institution will have to look for other means of terminating a contract if they have to, or agreeing with the individual that they have to wait until the case is over in court.
Okay. So my point is the 2 years offers a very good check and balance.
Well,
to ensure that the people who are
yes,
accused
but then this is not up to us.
Okay.
As only up to us as prosecutors. It involves the judiciary also, and a lot of it is that what the CJ has done now is he's set up an anti-corruption court. He's added the number of magistrates and judges to deal with that, so that we can be able to expedite. Okay. A lot of things that that is done in the judiciary is old in its traditions, especially like having to take notes manually, and then sometimes you have to wait for them to be prepared. But now we're trying to see how we can digitize that process to make it faster.
Okay.
Yeah.
Okay.